Welcome to the session. Today we are going to talk about the proposed National Sex Offenders Registry. Seeing the recent increase in sexual crimes, the NDA government has proposed to set up a National Sex Offenders Registry. By adopting this step, the government aims to follow the footsteps of countries like the US and UK. Although the proposal for this registry was given by the UPA government after the 2012 Nirbhaya gang rape case, it gained impetus after the juvenile rapist in Nirbhaya case was to be released in December 2015 after serving a jail term of 3 years. There was a lot of hue and cry on this release, but the Delhi High Court nevertheless decided in favor of the release. Sexual offences in India. India has 1/5 of the world's child population, and unfortunately, the country also has the largest number of child sexual abuse cases registered in the world. In December 2017, a government study had revealed that a child is sexually abused every 5 minutes in the country. Here are a few other related statistics. Please have a look. What has the government done so far? The government has made changes to the present rape law under the criminal law, including the IPC, CRPC, Evidence Act and the POCSO Act. The following changes were made. POCSO Act was introduced in 2012 with the aim of protecting children below the age of 18 from sexual abuse and assault. POCSO was enacted for all children, including boys and girls. It provides for the maximum punishment of imprisonment extending up to life. When we talk about the implementation of punishments, let's talk about capital punishment. In India, executions are rarely carried out, with just 4 recorded in the last decade. In the Nirbhaya case, the 4 men convicted were sentenced to death, though this has not been carried out yet. Why is there a need to have a registry? In India, there have been instances in the past where the convicted sex offenders have committed the crime multiple times. They have done the crime fearlessly again and again. So having a registry might act as a deterrent. Now let us look at similar registries by other countries. Registries are operational in some countries like Australia, the United States, United Kingdom, Canada, and few more on the same lines. But the United States and South Korea have gone a step further by making the sex offender registry public so that the community gets aware of the presence of the sex offender in their locality. The registry can be accessed through internet and it will provide the name, photo, physical appearance and residence of the sex offenders near them. The implementation of this registry is a major achievement for India. With the implementation, India has become the 9th such country in the world to do so. In the United States, the sex offender registry is available to the public, whereas in India, the registry will be available only to law enforcement agencies. Does the sex offender registry stop sex crimes? Making the registry public inculcates a sense of security in the public and in the community, but they have failed to reduce significant number of sex crimes. It is noted that such laws harden sex offenders and make them more likely to commit more sexual offenses because criminal behavior is attractive to registered sex offenders who live under tracking. What can be the potential difficulties that the offenders might face? In the USA and UK, as they are registered and their information is accessible by the public, former convicts find it difficult to find employment and places for residence, as many areas and localities are branded as sex offender free zones. They might also face a threat of violence and harassment from the people of the community where they live. The Indian minister also wants to include juveniles, persons standing on trial, and also the accused persons in the register. Being only accused of the offence does not make her or him the offender, and registering them will violate the civil rights and will have a bad impact on their life. Similarly, putting children on the register is also a violation of rights under the Constitution and also international obligations under the UN Convention for the Rights of the Child. What are the issues in the current system used in India? The issue of criminalizing of consensual sex under the POCSO Act of 2012. If 2 minors have consensual sex, they can be imprisoned for 7 years under this law. A study shows that most cases relating to this issue are filed by the objecting parents. So this issue of being on register for having consensual sex for lifetime has to be addressed. Here are a few figures showing how our criminal justice system has failed. Let us look at the broad objectives of the registry. At present, the database contains 4.4 lakh entries. State police forces have been asked to regularly update the database from 2005 onwards. This will help in tracking released convicts who have moved from one place to another. There are two reasons for starting the database from 2005. At most prisons, records before 2005 have not been digitized. Second, in many cases, the maximum punishment is life imprisonment, which is calculated as 14 years. So many convicted prior to 2005 will have served their sentences. Let us look at the key highlights of the registry. The National Crime Records Bureau will be the nodal agency. The offenders will be classified by their criminal history. This registry will store data for 15 years in case of those classified as posing low danger, 25 years for those presenting moderate danger, and throughout the lifetime for habitual offenders, violent criminals, etc. The databases will include names and aliases, identifiers including PAN and Aadhaar, information of date of birth, criminal history, fingerprints and palm prints, and various other details. It will only have details of persons who are aged 18 or more. Whenever the details of a convict are entered into a prison database anywhere in the country, the name will be uploaded to the registry. Appeals against a conviction will have to be updated by state prisons. An accused can be tracked until an acquittal. Let us look at the criticism. In some Western countries, there have been demands for a review of the decision to maintain a registry, amid a view that it does not serve as a deterrent or help people who have survived sexual violence. In India, critics have pointed out that most sex crimes are committed by a person known to the victim. After the Nirbhaya case, the country was up in arms about the safety of women, though in the past 6 years little has changed. The country really needs such a centralized record, but it has to be maintained cautiously, keeping in mind the interests of all the stakeholders. Few model descriptive questions have been mentioned here. Do attempt writing a 200 to 250 words answer for each of them. Here an ethics case study has been given. Please attempt writing an answer for it as well. Thank you.